Hello everyone, welcome back. In the previous lecture, we discussed two major schools of Hindu law, Mitakshara and Avyavaharika. We saw that under Mitakshara, the concept of coparcenary is central. Son acquires an interest in ancestral property simply by birth, and that birthright forms the basis of the joint family system. Today's topic is connected with that background. Today, we are going to understand the doctrine of pious obligation. This is one of the most interesting doctrines in old Hindu law. You may ask why? Because it shows that Hindu law was not merely a rigid set of legal rules. It was deeply connected with morality, religion, family duty, and social responsibility. Today, when we talk about debt, we usually think in contractual terms. A person takes a loan, that person signs the document, and only that person becomes liable. If someone else has not signed the document, we normally do not make that person liable. But traditional Hindu Mitakshara law looked at debt through a different lens. The question was not only who borrowed the money, the question was also, was the debt incurred by the father? Was it a lawful debt? Was it a moral debt? Was it free from illegality and immorality? And if the answer is yes, then one more question arose. Can the son's interest in ancestral property be used to repay that debt? This is the central idea of the doctrine of pious obligation. Now we'll understand the meaning of pious obligation. The doctrine of pious obligation means that a son has a religious and moral duty to discharge the just debts of his father. This duty was called pious because it was connected with the spiritual welfare of the father. In ancient Hindu thought, it was believed that if a person died leaving unpaid debts, his soul could suffer spiritual consequences. So, repayment of the father's debt was not treated as a simple financial transaction, but rather it was treated as a sacred duty, a duty of the son, a duty arising from dharma, a duty to save the father from the spiritual burden of unpaid debt. But over time, this religious and moral duty was converted into a legal rule. Courts began to recognize that the son, grandson, and great grandson could be made liable for the father's just debt. But here one classification is absolutely necessary. The doctrine did not mean that the son became personally liable like a borrower. The son did not take the loan, the son did not sign the loan document, the son did not promise to repay the money. So the credit could not simply proceed against the son's separate self-acquired property. The liability was connected with son's interest in ancestral or coparcenary property. In simple words, the son is not liable because he borrowed, he is liable because he had an interest in the ancestral property of the family. So the doctrine was not ordinarily personal liability, it was a liability attached to the coparcenary property. That is the first and foremost important thing that we have to understand. Now we'll understand the origin of the doctrine of pious obligation within Hindu law. To understand the origin of this doctrine, we must understand the concept of dharma in Hindu law. In Hindu jurisprudence, dharma is a very wide idea. It does not mean religion alone. It includes duty, it includes morality, it includes righteous conduct and social responsibility. And in the older Hindu legal system, it was also legal obligation. Law, morality, and religion were not kept in separate compartments. They were all blended together. So the son of a father's son, king, teacher, student, husband, wife, and other members of the society were all understood within the wider framework of the dharma. The son's duty towards the father was therefore not merely emotional. It was a part of dharma. The father gave life, protection, maintenance, and family identity. In return, the son was expected to perform certain duties. One of these duties was a discharge of father's lawful debt. That is how the doctrine arose. Its origin was religious as well as moral, but its larger application became legal. This is the journey of the doctrine, from religious duty to legal liability, from moral responsibility to enforceability against ancestral property. Now let us understand the difference between the liability incurred by a Karta and liability incurred by a father. Look closely at the distinction on your screen. This distinction is vital for understanding the doctrine. A Karta is a manager of the joint family. He manages the property, he represents the family, he may borrow money for family purposes, but his power is limited. An ordinary Karta can bind the joint family property only when the transaction is for legal necessity, benefit of the estate, or valid family purposes. For example, family maintenance, necessary marriage expenses, education, preservation of family property, payment of government dues, or necessary litigation expenses. All these are covered, but if Karta takes a loan for his personal use and without family necessity, he cannot bind the shares of other co-partners. He cannot say, I am Karta and therefore you all are liable to pay your share. That is not the rule. Now compare this with the father. The father has a special position under old Mitakshara Hindu law. If the father incurred a personal debt, even if the debt was not for legal necessity of the family, the son's interest in coparcenary property could still be made liable. Why, you may ask? This was because of the doctrine of pious obligation. So the father could bind the son's coparcenary interest in a way in which an ordinary Karta could not bind that of other copartners. That is the key difference. The Karta's power is based on legal necessity or benefit of estate. The father's special power was supported by the doctrine of pious obligation. Do not mix the two. They both relate to joint family property, but they are not the same. Now let's move on and understand a quick and simple example. Suppose an elder brother is a Karta. He takes a loan for his own personal business venture. The loan has nothing to do with the family necessity. Can he bind the share of his younger brothers? The answer is no, because he is only an ordinary Karta. Now take another example. Father takes a personal loan. The loan is not for family's necessity, but it is lawful, it is moral, and it is not for gambling, drinking, or some other illegal activities. Under the old doctrine, the creditor could proceed against the son's interest in ancestral property. That is the special position of the father. Now let us understand the difference between the ancient and modern treatment of the doctrine of pious obligation. Now this doctrine has changed over a period of time. In its ancient form, the doctrine was primarily religious in nature. It was connected with the father's debt. The idea was that if the father died with unpaid lawful debts, the son should pay those debts to relieve the father from spiritual suffering. So the ancient doctrine focused on religious conscience, filial duty, and spiritual welfare. But when courts began applying Hindu law in property dispute, creditor suits, mortgage cases, partition cases, and execution proceedings, the doctrine became more legal and more practical. The court started asking questions. For example, can the creditor proceed against the son's share? Can the doctrine apply during the father's lifetime? What if the father had mortgaged joint family property? What if the family was partitioned already? What if the debt was immoral? What if the debt arises from negligence or misfeasance done by the father? These questions gave the doctrine a modern judicial form. One important development was that under judicial treatment, the son's liability could arise even during the father's lifetime. It was not necessary to wait until the father's death. So we can summarize the evolution like this. The ancient doctrine was religious in origin. The modern doctrine was legal in application. The ancient doctrine focused on spiritual duty. The modern focused on enforceability against the coparcenary property. Now let us understand, when does this doctrine apply? Firstly, there had to be a debt of the father, grandfather, or great grandfather. Secondly, the person sought to be made liable had to be the son, grandson, or great grandson. Thirdly, the liability was connected with the ancestral or coparcenary property. Fourth, the debt had to be lawful and moral. It must not be immoral. It must not be illegal. It must be Vyavaharik and not Avyavaharik. And this brings us to the most important limitation of the doctrine, that is Avyavaharik debt. Now let us move on and understand what this Avyavaharik debt means. Avyavaharik debt is the son's most important defense under this doctrine. An Avyavaharik debt means a debt which is not fit for legal or moral recognition. It is often explained as the debt for a cause which is repugnant to the good morals. Think of it as a debt tainted by vice. If a father borrows money to, say, suppose gamble, to drink, for intoxication, and for immoral purposes, and for illegal activities, then the doctrine breaks down. The son can legally say, my share in the ancestral property is protected because this debt is immoral and illegal. But remember the litigation rule. Generally, allegations do not save the son. The son cannot simply say, my father was a person of immoral character. That is not enough. The son must prove a direct connection between a particular loan and the immoral or illegal purpose for which it was utilized. The court is not concerned with the father's general procedural character, the court is concerned with the nature of the specific debt. That is the real test of pious obligation. Now let us understand which debts are exactly out of the ambit of doctrine of pious obligation. Firstly, the Avyavaharika debt. Secondly, the gambling debt. Thirdly, the debt incurred for intoxication, and then also for the criminal activities. If some suretyship debt is involved, that may also go outside the ambit of pious obligation if there is involvement of some tortuous liability. But the tortuous liability requires a careful approach. A debt arising from a tort is not automatically avyavaharik. The question is the liability morally tainted? Is it illegal? Is it repugnant to good morals? If the liability arises merely from the negligence or civil misfeasance, it may not automatically fall outside the doctrine. We will understand this more clearly when we discuss SM Jakati versus SM Borkar case. Now let us move on to understand antecedent debts and alienation. What is antecedent debt? This concept becomes important when the father alienates joint family property. Alienation means selling, mortgaging, or otherwise transferring a property to someone else outside the family. Under old Hindu law, the father had a special power to alienate joint family property, including the son's share, for the repayment of his antecedent debt. Now, what is antecedent debt? Antecedent debt means a debt which is prior in time, the debt that was already existing. The debt must already exist before alienation. It must not be independent of the alienation. The debt and the mortgage cannot be part of one single transaction. Let us understand this simply. If the father first borrows money and later mortgages joint family property to pay off the earlier loan, then the debt may be antecedent. But if the father borrows money and mortgages the property in the same transaction, then the debt is not truly antecedent. The debt must be earlier and it must be separate and independent. And of course, it must not be immoral or illegal. Now let us understand the effect of partition. Partition means joint family property is divided. After partition, the father is no longer the manager of son's separate share. So after partition, the father cannot alienate the son's share as manager. But does partition destroy the son's pious obligation for the father's old debt? The answer under the old Hindu law was no. Partition did not automatically destroy pious obligation. If the debt incurred was before partition and no proper arrangement was made at the time of partition for repayment of the debt, then the son's separate share could still remain liable. So remember this distinction. Partition ends the father's power to alienate the son's share as a manager, but partition does not automatically end the son's pious obligation for pre-partition debts. This distinction is very important. Now let us move on to some case laws. We will be covering 3 case laws in this. On the web page I have given several of them, but for the purpose of this lecture we will be discussing only 3 of them. One being Brij Narain versus Mangla Prasad, second one being SM Jakati versus SM Borkar, and third one being Keshav Nandan Sahai versus Bank of Bihar. So let us now begin with the first case, that is Brij Narain versus Mangla Prasad. This was an important Privy Council decision on antecedent debt. The issue was whether the father could bind the son's share by alienating joint family property for payment of his own debts. The Privy Council clarified the rule. An ordinary manager can alienate joint family property only for necessity. But the father has a special power. He can alienate joint family property including the son's shares for the payment of his antecedent debt. But there are 2 limitations. First, the debt must be antecedent in fact and in time. Second, the debt must not be immoral. This case is important because it clearly separates the power of ordinary Karta from the special power of the father. It also gives structure to the idea of antecedent debts. So whenever we discuss father's alienation for antecedent debts, Brij Narain case is the foundational case. Now let us move on to the second case, that is SM Jakati versus SM Borkar. This case was before the Supreme Court. In this case, the father was connected with the management of a cooperative bank. Because of his negligence or misfeasance, a payment order was passed against the father. The family property was attached and later sold in execution. The sons objected. They argued that liability arose from misfeasance and therefore it was not avyavaharik. They also argued that there had been a partition, so their share could not be attached. The Supreme Court rejected this argument. The Supreme Court explained that avyavaharik does not mean every liability arising from the negligence. It means a debt for a cause repugnant to good morals. In other words, the debt must have a moral taint. It must not be connected with illegality or immorality. Mere negligence or civil misfeasance is not enough. So the sons could not escape the liability merely by calling the debt Avyavaharika. The court also recognized that pious obligation could survive partition in relation to pre-partition debts. The case is important for two reasons. Firstly, it narrows down the meaning of Avyavaharika, and secondly, it shows that the partition does not automatically wipe out the son's liability for old debts. Now let us move to the third case, that is Keshav Nandan Sahai versus Bank of Bihar. This case is useful because it shows both the strength and the limitations of the doctrine. The bank had obtained money decrees connected with the debts incurred by the father. After the father's death, execution was sought against the heirs. The family argued that partition had already taken place and therefore the doctrine should not apply. The question was, if the father's debt were incurred before partition, but the decree of execution came later, does the son's pious obligation survive? The court applied the old principle and held that pious obligation may survive partition for pre-partition debts. So partition by itself was not enough to defeat the creditor. But the case also shows an important limitation. The doctrine applies to sons, grandsons and great-grandsons. It cannot be extended to wife merely because she received the share in partition. So the wife's share could not be attached merely on the basis of pious obligation. That is why this case is very useful. It shows that the doctrine could survive partition against son, but it cannot be stretched beyond its proper scope. Let's move on to understand the present legal position of Doctrine of Pious Obligation. When it comes to the present legal position, there are questions like where does the doctrine stand today? For modern transaction, the standalone Doctrine of Pious Obligation does not survive an independent ground of liability. The relevant provision for this is Section 6, Subsection 4 of Hindu Succession Act 1956. It was substituted by Hindu Succession Amendment Act of 2005. After the 2005 amendment, no court can recognize a right to proceed against son, grandson or great-grandson for recovery of a debt due from his father, grandfather or great-grandfather solely on the ground of pious obligation. So for debts contracted after 9th of September 2005, a creditor cannot say this is the father's debt, therefore the son must pay because of pious obligation. That old rule no longer applies as an independent basis post 2005 debts. This does not mean that the father is free from his own debts. The father remains personally liable under ordinary civil and contractual laws. What the amendment does is different. It creates a shield around the son's coparcenary interest. It prevents the father's personal liabilities from automatically swallowing up the next generation's birthright. But there is also a savings clause. The abolition is not completely retrospective. If the debt was contracted before the commencement of 2005 amendment, then the old creditor's right may still be protected. So the present position is for post 2005 debts, pious obligation is abolished as a standalone ground. For pre 2005 debts, old rights may still survive depending on the facts. So now let us sum up this entire lecture briefly. The doctrine of pious obligation was a rule of old Mitakshara Hindu law. It began as a religious and moral duty of the son to repay the father's just debts. The idea was that repayment would revive the father from spiritual consequences of unpaid debt. Later, courts converted this duty into a legal rule. Under that rule, the son, grandson and great-grandson could be made liable through their interest in ancestral or coparcenary property. But the debt had to be lawful. It had to be moral. It must not be avyavaharika. The son was not personally liable like a borrower. His coparcenary interest was liable. The father had a special position. An ordinary Karta could bind the family only for legal necessity or benefit of estate. But the father could bind the son's coparcenary interest for his own lawful debts because of pious obligation. For alienation of joint family property, the father's debt had to be antecedent. That means it had to be existent before the alienation and must not be part of the same transaction. Partition did not automatically destroy the son's liability for pre-partition debts. But after partition, the father could not continue to alienate the son's separate share as a manager. The doctrine has limits. It did not apply to immoral legal debts. It did not apply to illegal debts. It did not apply to Avyavaharika debts. It did not apply to wife's share merely because she received partition property. And after the Hindu Succession Amendment Act of 2005, the doctrine had been abolished for future debts as an independent ground of liability. So today the doctrine of pious obligation is mainly important for understanding the historical structure of Hindu law. It also shows us how old Hindu law moved from religious duty to legal liability. It also shows us how modern statutory law has moved away from religiously grounded family debt and liability. In that sense, this doctrine forms a bridge between ancient legal thought and modern codified Hindu law. With this, we complete this discussion on doctrine of pious obligation. In the next lecture, we will move from uncodified Hindu law to the codified Hindu law, and we will begin with the Hindu Marriage Act 1955. Thank you. Keep learning.